Your medical malpractice case goes all the way to trial after 2 or 3 years of litigation. And now, at the very end of the case, the jury decides the case in your favor. And they give you a significant amount of money as compensation for all of your harms and injuries. Seconds later, after the verdict is announced, the defense lawyer jumps up out of his chair and says, "Your Honor, I move to dismiss this case and the verdict." Number one, can he do that? Number two, you want to know what that's called? Come join me for a moment as I share with you some incredible information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is yes, the defense attorney can do that. And what it's called is a JNOV. Those are initials that stand for a legal term that we learn in law school called judgment non obstante verdicto. That's some fancy Latin term that says, hey, judge, this big verdict that just came down is against the weight of the evidence. This big verdict is not supported by the evidence that we heard in this trial. And because of that, I want you to dismiss this verdict. I want you to throw out the injured patient's case, and that'll be the end of it. Will the judge do it? The answer is maybe yes, and maybe no. There's a lot that goes into answering that question. But you should know, at the very end of the trial, when the jury comes back with their verdict, they have decided who is more likely right than wrong. You see, an injured patient who brings a lawsuit claiming that the doctor was careless and that his carelessness was a cause of their injury. Now, we have to show to the jury that we are more likely right than wrong, that what we are claiming is true. We don't have to show with absolute certainty that what we are claiming is true. We don't even have to show beyond a reasonable doubt. That's got nothing to do with these civil lawsuits. Instead, we only have to tip the scales of justice ever so slightly in our favor in order to justify a verdict in our favor. If the jury determines that your doctor violated the basic standards of medical care and that his carelessness was a cause of your injury, and now your injuries are significant or permanent, the jury has to decide how much money you are to receive as compensation. And they will evaluate all the different elements of damages. Maybe it's pain and suffering for what happened to you in the past, and the pain and the suffering you are likely to endure into the foreseeable future, and your economic losses. Those losses may be your lost earnings, as well as non-economic losses involving pain and suffering. So now the jury comes back with their decision, and they give you a verdict in your favor. The doctor loses, the hospital staff loses, but the defense is not happy with that verdict. So now they get up with righteous indignation. Judge, I move to dismiss this verdict. I move for a JNOV, judgment non obstante verdicto. And you'll find very few attorneys actually use those Latin phrases. The judges know what those abbreviations are if we say JNOV. They know that they're trying to make the argument that, hey, this verdict is not supported by the evidence. And now the judge has to decide. Is he going to make that decision right then and there? Many times the judge will not decide it right then and there. You want to know why? He will want to give the attorneys an opportunity to present whatever arguments they're making in written form. And this way it also gives the other side, the winning side, an opportunity to rebut those arguments that are being made by the losing side. The judge will typically say to the defense attorney, listen, I want written papers on your request within the next 30 days. And plaintiff's attorney, the injured patient's attorney, you now will have 30 days after that in order to respond. If the judge decides in the defense's favor that there was insufficient evidence, he may turn around and he has a number of options available. He may say, you know what, you're absolutely right. There was insufficient evidence to justify a verdict. We're going to throw this case out, and that's the end of it. Or he may say, yes, there was sufficient evidence on the issue of who's responsible, but on the issue of damages, I don't see that certain elements of damages, let's say for medical expenses, were justified. We're going to reduce that particular element of damages, and now you either live with it or go take it up on appeal. Or the judge could turn around and say, you know what? I agree with you, defense attorney. Those damages are way too high, the amount that was given to the injured patient. I'm throwing out that portion of it, and I'm directing that everybody come back for another trial only on the issue of damages. So now you're going to have a new trial just to decide how much money this patient is to receive. Now get this, if the judge decides to reduce the verdict, the amount, the defense is going to turn around and say, no, you know what? I appreciate you reducing the verdict, judge, but it's not good enough for us. We still think we are right. We're going to take this issue up on appeal. Now we're going to spend another 1 or 2 years appealing this issue, and we want the higher court, the appellate court, to make a decision in our favor. And a number of options could arise in the appellate court. So, to get back to the original question, at the end of the trial, don't be surprised if you win your case, the defense attorney jumps up and yells out, "Your Honor, I move for a directed verdict in our favor," and that you dismiss this entire case. So why do I share this great information with you? I share it with you just to give you an inside look at what happens in these civil lawsuits involving medical malpractice here in New York. You know, I understand and I recognize that you're watching this video because you likely have questions of your own. Well, if your matter did happen here in New York and you have not started a lawsuit yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.